In what way does the Court's observation that the Second Amendment codified a pre-existing fundamental right to bear arms affect your conclusion that the Second Amendment does not protect a fundamental right?
My conclusion in the Maloney case or in the U.S. Sanchez-Villar was based on precedents and the holding of precedents that the Second Circuit did not apply to the states.
Well, what's
your question?
Excuse me, I'm sorry, I didn't mean to interrupt you. What's your understanding of the test or standard the Supreme Court has used to determine whether a right should be considered fundamental? I'm not asking a hypothetical here. I'm only asking about what the Supreme Court has said in the past on this question. I recall, for instance, the Court emphasizing that a right must be deeply rooted in our nation's history and tradition, that it is necessary to an Anglo-American regime of ordered liberty, or that it is an enduring American tradition. I think I've cited that pretty accurately on what the Court has held with regard to what is a fundamental right. Now, those are different formulations from the Supreme Court's decisions, but I think the common thread there is obvious. Now, is that your understanding of how the Supreme Court has evaluated whether a right should be deemed fundamental?
The Supreme Court's decision with respect to the Second Circuit incorporation, Second Amendment incorporation doctrine is reliant on old precedent of the Court, and right. I don't mean to use that as precedent that doesn't bind when I call it old. I'm talking about precedent that was passed in the 19th century. Since that time, there is no question that different cases addressing different amendments of the Constitution have applied a different framework. And whether that framework and the language you quoted are precise or not, I haven't examined that framework in a while to know if that language is precise or not. I'm not suggesting it's not, Senator. I just can't affirm that description. My point is, however, that once there's Supreme Court precedent directly on point and Second Circuit precedent directly on point on a question, which there is on this incorporation doctrine and how it uses the word fundamental, then my panel, which was unanimous on this point, there were two other judges, and at least one other panel on the Seventh Circuit by Judge Easterbrook has agreed that once you have settled precedent in an area, then on a precise question, then the Supreme Court has to look at that. And under the deference one gives to stare decisis and the factors one considers in deciding whether that older precedent should be changed or not, that's what the Supreme Court will do.
In Sanchez-Villar, you identified the premise that a right to possess a gun is not fundamental, and the conclusion that New York's ban on gun possession was permissible under the Second Amendment. But there's not a word actually connecting the premise to the conclusion. Without any analysis at all, that footnote that you wrote leaves the impression that unless the right to bear arms is considered fundamental, any gun restriction is necessarily permissible under the Second Amendment. Is that what you believe?
No, sir, because that's not, I'm not taking an opinion on that issue because it's an open question. Sanchez
so you admit it's an open question?
Well, I admit that the courts have been addressing that question. The Supreme Court, in the opinion authored by Justice Scalia, suggested that it was a question that the court should consider. I'm just attempting to explain that U.S. versus Sanchez was using fundamental in its legal sense, that whether or not it had been incorporated against the states. With respect to that question, moreover, even if it's not incorporated against the states, the question would be, would the states have a rational basis for the regulation it has in place? And I believe that the question there was whether or not a prohibition against felons possessing firearms was at question, if my memory serves me correctly. If it doesn't, but even Justice Scalia, in the majority opinion in Heller, recognized that that was a rational basis regulation for a state under all circumstances, whether or not there was a Second Amendment right.